justice, the people's champion, justice, justice for all, justice under the law, justice, Jamaica demand, right to life, right to liberty.
It's a beautiful Monday here in Kingston. I trust it's the same for the rest of our beautiful island. My name is Michael Jackson, Executive Director of JFJ.
And I'm Jade Williams, Policy Research and Advocacy Specialist at JFJ.
All right, thank you so much to our listeners. We are happy to have you joining us via Radio Land. Those who are watching via YouTube, always certainly happy to have your company and you listening in and paying attention to what's happening in the justice and human rights space. And today we're going to be discussing the Jury Act a little bit more. Last week we focused on the increases and whether or not we should abolish the jury system that we have or maintain the hybrid system that currently exists. So we're going to go a little bit further with the discussion today, and we're going to be joined by Zulika Jess, attorney at law and opposition spokesperson on justice, as well as John Clark, attorney at law, former board chair of JFJ.
Yes. All right. Are we...
You want me to go right into the week that was?
Yes, I do.
All right. So the week that was, I want to quickly discuss the matter of police fatal shootings, and we're going to go back to that conversation towards the end of the program. But we saw, I believe, in the Saturday Gleaner, where current Member of Parliament and Minister of Agriculture, the Honorable Floyd Green, who is a witness in a trial that is of interest to JFJ. And the headline of the Gleaner said, "I was afraid." And it spoke to the reluctance, understandably so, of Floyd Green in coming forward, in providing a witness statement in his witnessing of the killing of Matthew Lee and two others. And this killing, for those who are not aware, took place in January of 2013, broad daylight in Arcadia Drive in Kingston. Matthew Lee is a middle-class young man who was driving with two others along Constant Spring thereabout, where they were killed by members of the Jamaica Constabulary Force in 2013, as I indicated. There were the allegations of trying to paint these young men, all three, as criminals. The family, with the JFJ support from then, the support of Amnesty International. So if you remember some of those reports, Waiting in Vain, if you go on JFJ's YouTube page now, you will see a documentary, if you will, called Victims' Voices, and you will see Matthew Lee's mother and family in that documentary that JFJ produced. And we have been following this matter my apologies, from 2013. And again, the allegations of firearm being found and witness tampering, threats, 2013. So we can't speak much on the case because it's currently before the courts. But I just wanted to highlight that though many things have improved, and we have much to celebrate, we still have a far way to go. Because we do have families who call and they're fearful of speaking. We have witnesses sometimes who call and they're fearful of going to Indicom, and we have to encourage them, make a report. And we have to be mindful as well, because JFJ, we don't offer witness protection. So though much has changed and we have come a far way, every time We say, why JFJ attack? Everybody a criminal. We have to be careful because we have the Matthew Lees in some of the 311 people who were killed last year. We have witnesses who, like the minister, they're afraid to come forward. We have witnesses who say they have come forward and in their minds and based on their situation and analysis, you see a vehicle passing and you feel intimidated. We have documented, for example, during the state of public emergency, where people were detained and then the police, according to their reports, come and revisit the homes and they feel intimidated, they feel threatened. So while we have much to celebrate, 2013 is still not far. It's a short time ago, and we still have some of these situations happening. So I want to make it very clear that on behalf of JFJ, we continue to celebrate our officers. Most are doing excellent work within the ambit of the law, but we can't negate the experiences of people and label everybody as criminals. And as we have articulated, if a criminal or someone who is accused of a crime poses no immediate threat, that is why the courts are there, due process. So the Matthew Lee case, again, is currently before the court, so we can't make much pronouncement on it. But JFJ, we have 2 team members now in the court, observing on behalf of the family. And at the appropriate time, we will speak. But I hope that the family will seek or receive justice. But it's now 2026 and the trial just started.
Yes.
2013, 13 years later, the trial just started, which is why our collective voices are so important. So again, body cameras, they're not a panacea. We have never claimed it to be. But they are so important in offering that independent account, because you may not have a witness. It's the person who is deceased and the person who did the fatal shooting. And of course, dead man tells no tale, because the person is dead, they're gone.
Right.
And that is why the body camera is so important. Again, not a panacea, but Jade and I, we will have more discussion towards the end of the program on that particular matter. All right?
All right, thank you so much for that, Mikkel. We'll go quickly into our right of the week and our trivia question for the week. Our right of the week for this week was taken from our Jury Act again, and it speaks to the entitlement to serve on a jury without loss of remuneration. So that is section 19A of the Jury Act, and it states that when a person receives a summons for jury duty, they are to inform their employer as soon as possible, and the employee is then entitled to time away from work to complete his service without any loss of the remuneration or any other benefit or advantage to which he is entitled. So you should be able to do your jury duty once you inform your employer that you have jury duty without any negative effects on your continued employment, right? We also have a trivia question for today, and the trivia question is, which 2 lists of registered Jamaicans are potential jurors taken from? Which 2 lists of registered Jamaicans are potential jurors taken from? So you can respond in the YouTube chat, or you can send a WhatsApp to 2397583, or you can respond on our Instagram pages at JA4Justice. Alright, so our substantive topic for this week, proposed amendments to the Jury Act. We know that the bill was tabled 2 weeks ago and the debate would have started, but that was paused on the 20th of January 2026. Some issues were raised by opposition leader Mark Golding. But in the bill, it would propose to increase the stipends for jurors, which we discussed the stipend increase last week from 2,000 to 6,000, plus 2,000 for those persons who attend jury duty but are not empaneled. It also introduced measures to address jury tampering, allowing for the prosecution to apply before a trial for a judge alone trial, where there is evidence of a real or present risk of jury tampering, or during a trial the judge may discharge the jury, and continue without one, or they may terminate the trial where there is evidence of jury tampering.
All right, so we have MP, first time MP, congratulations to Miss Zulika Jess. Miss Jess, do we have you? Oh, we don't have her as yet. And we are waiting to be joined as well by our former chair, board chair, John Clark, who is also an attorney at law.
Yes.
Miss Jess?
Yes.
I was saying congratulations to you.
Thank you.
Yes, September passed long ago, but it's the first we're having you on the radio show, so we're happy to have you.
Thank you so much. It's good to be here with you.
Thank you. You're here with Mikkel and Jade.
Yes.
So,
Hi, good afternoon, everyone.
Afternoon.
Ms. Jess, if you could, last week we had extensive discussions on the increase, the proposed increase. So I think we've settled on that matter. And based on comments made by you and others of the parliamentary opposition, it seems there is a collective welcoming of the increase. But it's the other matters that you're raising some concerns about. So if you could walk us through the concerns, and then we can go fulsomely into the discussion.
Absolutely. So you are indeed correct. We have absolutely no objection to the proposed amendment as it relates to increasing the stipend, which is paid to persons who serve as jurors, as well as those who do not serve as jurors but would have attended court for jury duty or jury selection but were ultimately not chosen. It is only fair because we do understand that persons would have incurred certain expenses. Persons travel to get to the court. Persons may have taken days off in order to participate in jury duty. So it is only fitting that they are adequately reimbursed for their expenditure. So that is not in dispute at all. What is really contentious at this point is the issue of trial by judge without a jury. So usually you know that the jury would be the jurors would be the judges of the facts, and the judge, as in the legal judge, would be the judge of the law. So usually you have both of them working together. What this proposed amendment is seeking to do is to eliminate the use of trial by jury in circumstances where there is a real or present danger of jury tampering. And I know that persons may think that, okay, perhaps this is just a limited situation whereby we can do away with the use of a jury instead of having to start the trial all over again. But our position is that the minister would have spoken last week, well, the week before, that he would be sending the Jury Act to a joint select committee of Parliament so that there can be a very extensive consultation process, and thereafter we can make a determination as to what sections we're going to reform. So our view is that you should really properly send the act to a joint select committee, have widespread consultation, hear from the defense, hear from the prosecution, hear from persons who serve as jurors, hear from members of the public, and then make a determination as to what reform we wish to adopt here in Jamaica. Do we wish to do away completely with trials by jury? Do we wish to have a hybrid system like what obtains presently continue? Or is it that we feel that the middle ground of allowing for a judge to discharge a jury in circumstances where there is jury tampering, do we think that that is a reasonable approach to take? It may very well be that it is, but we're saying that at this point, send the bill, send the act to a joint select committee of Parliament. Let's have that discussion and then make an informed decision, as opposed to trying to sneak it into a bill which is really supposed to be non-contentious and just about increasing stipends. This part is contentious.
All right, thank you. We now have John Clark, but we're going to take the break. So for purposes of our listeners, the consensus so far is that there is agreement on the juror stipend, but there are some other issues, the jury tampering, and John Clark is the appropriate person to speak on that particular matter, given he was one of the attorneys in the popularly referred to Vybz Kartel case. But also some trial readiness components are there that I would also love to hear Mr. Clark's perspective on, as well as Ms. Jess. So let's take a break and then we pick up with the rest of the interview.
The Institute of Chartered Accountants of Jamaica presents the IFRS Workshop 2026 under the theme Resilience and Recovery. Join leading experts on January 30 and 31 in person at Summit 16 Chelsea Avenue or online via Zoom. Learn about IFRS 18 and 19, IFRS for SMEs, AI in financial reporting, sustainability standards, and financial lessons from Hurricane Melissa. Plus, earn your CPD credits. Register now at icaj.org. Deadline January 23. Don't miss it.
Are you ready to turn your sales and marketing skills into high earnings? Nationwide 90FM is searching for business development executives to help us grow our business and build lasting client relationships. If you have experience across all stages of the sales cycle and possess strong communication, negotiation, and time management skills with a proven sales track record, this opportunity is perfect for you. Join our team and work with the top corporate brands, media agencies, and of course, our on-air personalities. Enjoy networking opportunities, professional growth, and competitive commissions. Ready to take the next step? Send your resume to hr@nationwidenewsnetwork.com today.
Welcome back to Let's Start Justice. We're discussing some of the proposed amendments to the Jury Act, which was tabled in the House 2 Tuesdays ago. Yes? And we're joined by attorneys at law, Zulika Jess and John Clark. Mr. Clark, happy to have you.
Thank you for the invite. I'm happy to be here.
Great. Let's start with the conversation about the proposal to address the matter of jury tampering. We heard from Ms. Jess earlier to indicate that she welcomes the stipend, but believes that a broader comprehensive review is necessary in a joint select committee rather than what one could perhaps call a piecemeal approach in looking at some of these proposals. I'm not sure if you have any views on the jury tampering component or just generally, please.
Well, I believe that it is that the amendment, and I heard the amendment in relation to the increasing of the stipend, which no one's taking an issue with. But then the amendments, as the proposed amendment as relates to the jury tampering issue, is a fundamental change in our law. Because what it would fundamentally mean is that some citizens, despite their desire, will no longer be able to be tried by a jury of their peer, but will ultimately have to have their matter tried by a judge alone in situation where that particular citizen may not have played any role in the alleged jury tampering. So the provision that I've seen in the bill so far, we're just accepting essentially what is in England, and England doesn't have a constitution that like what we have. And then ultimately it begs the question in situations where a citizen would say, I prefer to be tried by a jury for whatever reason, selecting their statutory right, and then somebody outside of that person made the decision that, I believe that there is a real and present danger of jury tampering. And in those situations, that person can be deprived of their liberty. And in light of that, it is some fundamental issues that will have to be considered by our legislators, and one would hope that this particular amendment would not be rushed through the Parliament in light of that, because it will have implications for many of our citizens who may very well have their life and their liberty taken from them just by this particular amendment itself.
Yeah, I know Jade has a question, but Jade, if you could just allow me to ask Ms. Jess this one, because just from a cursory view just now of the UK system, which we're seeking to mirror, Ms. Jess, and you touched on it earlier, it seems as if the consultation is largely with the prosecution, who is a representative of the state, a body within the executive branch of the state. So is that possible executive overreach? How is that viewed from your lens as a defense attorney, and certainly as the opposition spokesperson on justice?
And that is part of the issue we have, because we do not feel that it is in the interest of justice for the prosecution and the prosecution alone to have the option of making that election. What the proposed section contemplates or provides for is exactly just that the prosecution will be able to make that application for there to be a trial by judge alone without there being a jury. It doesn't allow for the defense an opportunity to make such an application if they so desire. And if we bear in mind the whole rationale of having a trial by jury, it's almost as though the jury exists as the final hope against the government excess, against excess by judge. And so when you make that and you insert a provision which doesn't allow for equity or balance, then you're really in essence depriving the ordinary Jamaican of potentially one of the safeguards that exists, one of the safeguards to protect the justice system and ensure that there remains public trust and public confidence that our system will work for everybody.
Mm-hmm. Thank you.
Thank you. Mr. Clark, I wanted to bring back to the provisions in the bill. We saw a few of them seem to refer to a new trial readiness procedure, where a judge would be, considering, in confirming a trial date, considering status of disclosure and witness availability, readiness of the parties, the length of trial, etc. I was curious as to whether or not this was not a duplication of our case management procedure that we already have, or if this would actually have a positive effect on, the delays that we're seeing in terms of starting trials.
Well, ultimately, it is to answer your question, as relates to the case management rules that we have, those rules are typically in the procedural rules and not in a specific legislation. Mm-hmm. And whilst I welcome the fact that Parliament is taking the view to try and legislate how it is that preparatory hearings are held in Jamaica, one would hope that we would do a far more comprehensive approach to this thing, bearing in mind that many of the matters remain long before the court, because we have a system and a culture now where the prosecution is generally not ready for a trial, and they're generally not ready for a trial, and the trial dates, the preparatory hearings are set just to ensure that the Crown is ready and nothing more. Mm-hmm. So what we're looking for ultimately is that there is a review done as it relates to fairness on both sides. And Jamaica does not have a system right now where a defense counsel can apply, for example, for an indictment pursuant to a statutory indictment to be quashed on the basis of certain things like delays, etc. So what most defense lawyers do is rely on the common law. Mm-hmm. Or if Parliament is seeking to introduce provisions for preparatory hearing, it should go both ways and will ensure that the court can actually function in a more effective manner.
Yeah, Mr. Clark, what I found interesting as well with the proposed new section, and it's called New Section 2, Subsection 6. And just to read it for purposes of the listeners, this provision outlines the matters a judge must consider in confirming a trial date, including the status of disclosure, witness availability, readiness of the parties, estimated trial length, and whether any issues remain that may affect the scheduled trial date. So going beyond case management readiness, if you will, I found the insertion curious, given your own call for the Speedy Trial Act, and that without more, I'm not sure exactly how this would help. Because one would think that, as you just outlined, if it is that my constitutional right to a speedy trial, which we have in Jamaica, then what exactly is the purpose of the provision without more? Is my question, if you could help me think through it a bit.
I think the best person to answer that would be the minister when he's invited to come on the program. Mm-hmm. But the concern I have is that Jamaica does not have a comprehensive and modern criminal justice administration law that looks at what have been the development in other jurisprudence as it relates to how criminal justice is being administered, which look at the fact that the circuit court is now heavily overloaded with matters just being transferred there. And that's some of the matters that are transferred to the circuit court. The trial, the preparatory judge, that is the case management judge, can really say that this is a nonsensical case. It's going nowhere, but then there's no clear legislative provision that empowers the judge to entertain an application by the defense to throw out cases before them that don't have, should not be wasting the court's time. Mm-hmm. And essentially what our justice system is doing is waiting on the DPP's office, which is already overburdened, to carry out the responsibility and the examination as to whether or not this is a matter that they will want to discontinue. And essentially, what we have is our judges being overworked and not being fully empowered to deal with some of the situations that in the same manner in which their counterparts are able to deal with them in other jurisprudence, other jurisdictions.
Yes. We have Miss Jess. Miss Jess, I'm not sure if you heard the discussion just now, speaking to one of the new sections being proposed, which is around trial readiness. Jade,
yes,
if you could just bring in Miss Jess on that and ask the question, please.
Yes, so, the section speaks to the new trial readiness procedure that before confirming the trial date, the status of disclosure, the witness availability readiness of the parties, estimated trial length, and any other issues that might affect the scheduled trial date. And we were asking Mr. Clark if this provision would, what effect would it have without more, considering that we have previously been looking at trying to put in legislation to support our trial within a reasonable time, our speedy trial provision in our constitution. So what effect, if any, would this trial readiness provision have?
Well, the truth is we found it rather odd for that particular provision to be contained in this specialized piece of legislation. It really, quite frankly, we found it almost illogical, because one of the points that was raised is that these are really matters to do with procedure and not so much the substantive act. And so usually you would find these kinds of procedural matters contained in procedural pieces of legislation, things like your civil procedure rules, things which literally set out how you go about the conduct of a trial, not so much in the legislation or legislation that is specifically supposed to be addressing the jury system. So we found that to be almost inconsistent with how we usually go about inserting certain provisions in our jurisdiction. Perhaps it obtains in other more mature jurisdictions, but it certainly isn't one that we foresee necessarily inuring to the benefit of practitioners here in Jamaica. So that is actually one area that we raised in our list of concerns with the proposed amendments. We don't think it should be there, quite frankly. We think it properly belongs elsewhere, but not in the Jury Act.
Mm. All right, thanks so much. Mr. Clark, you seem to have a full reading of the proposed amendments. Were there any other areas in your estimation you think welcoming, need a little bit more? Any other views?
The major concern I had is I also read the minister's statement.
Yes.
And the main concern I had is that there seems to be, and there is a development, I would say, that has been taking place across the legislative history of Jamaica, where most of the amendments that are being made to legislation are being made in a manner that will disadvantage criminal accused persons. And ultimately...
Mr. Clark, my apologies. Can you hold that thought for me? We are upon the break, a minute behind. Please, just hold the thought. We take the break.
The National Rural School Bus Program is getting smarter. With your child's student ID card, parents receive real-time notifications every time they board or exit the bus. Each card is unique and securely linked to the Ministry of Education, Skills, Youth, and Information database. Tap on, tap off, and parents stay updated instantly. So, how do you register? Number 1, visit jamaica-district.mysmartterm.com/bus-portal/registration. Number 2, enter your child's details. Number 3, upload supporting documents. Number 4, submit your application. It's that easy. Safer, smarter, more secure. Register today and ride with peace of mind.
Welcome back to Let's Start Justice. We're discussing some of the proposed amendments that were tabled in the House 2 weeks ago, and we're joined by attorneys Zuleika Jess and John Clark. Before the break, Mr. Clark, you were explaining your view on the legislative trend, if you will, that you see emerging. If you could just pick up where we left off, please.
Yes, it seems as if the right of the criminal accused persons are always under an attack without perhaps mature consideration in relation to why the rights existed in the first place. Mm-hmm. So, for example, we started with a situation where we had 12 jurors. That number was now reduced to 7. And when the number was reduced to 7, the issues as it relates to us having a difficulty with persons participating in the jury process, Parliament didn't see it fit to give a comprehensive review to that particular aspect. We just simply reduced the numbers. So what it is that instead of trying to fully appreciate why the system exists, what are the benefits of the system, and how things can be taken to improve the system, the jury system has always, in my view, seemed to be on the attack, with many attempts being made to whittle it down to the point where it may no longer serve the purpose it truly was created to serve from day one.
Mm-hmm. Yeah, thank you for that. And Ms. Jess, this is exactly the point, because while many attorneys, human rights groups agree that a hybrid system should be maintained, as Mr. Clark just outlined, there seems to be, the trend or the move, the trajectory towards perhaps abolishing the jury system altogether, considering that most matters are already heard by judge only when you look at the parish courts and the types of matters being prosecuted now, gang-related trials and so on. Mm-hmm. Any views there? And how much more hybrid can we get in a hybrid model that currently exists?
So I do appreciate the concern raised by counsel. The fact is we've had quite a few offences which have fairly recently enough, been introduced as being triable by judge alone. You think about the lot of scamming legislation, as they're commonly referred to. Those are tried by judge alone. So I do understand the feeling and the perception that perhaps it's certainly making it not the best time for someone to be accused of a criminal offense in Jamaica. But here's the position. I think it is important to strike a balance and to always aim for justice in every situation. Justice for the accused, justice for the alleged victims, and overall to ensure just justice in our society. What I can say, though, regardless of what might have obtained in the Parliament prior to now, in terms of certain pieces of legislation being introduced and passed without much fanfare, I can say with a fair degree of certainty that those days are over. I think that this present Parliament, as constituted now, we would have made it very clear that we're not just showing up to rubber stamp the legislation that the government comes with. And people saw that on Tuesday. On Tuesday, the minister came to the Parliament, making it very clear that he intended to take the bill through all the stages and to have it passed on that day because he felt it was non-contentious enough. But we had a robust opposition that was very firm in defending the rights and justice for each and every Jamaican. And so we saw where the minister actually paused the debate. So the bill did not just go through all the stages and was all. And we're hoping that, good sense and logic will prevail and that the points which were raised by the opposition in Parliament will be given due consideration so that we can continue to protect what we believe is a very fundamental part of our justice system, and that is the right to a trial by, members of your own peers, your jurors, who are supposed to represent diverse minds, bring in diverse experience, diverse background, so that you can have fairness if it is that you are brought before the justice system, whether criminal or civil, because we do note that the proposed amendment would also speak to jury trials in civil matters. So sometimes people think that they will never have to interface with this system and make the thing just pass because of criminals. It affects every one of us because you don't know when you may have to come before the court, perhaps not for a criminal matter but a civil matter, and your matter has the potential to be tried by a jury or these amendments would affect you, because one of the amendments that we have not spoken about, one of the proposed amendments, is in the case of civil trials. The proposed amendment that they're seeking to introduce would require that the party who is applying to have a trial by jury bear the cost and the expense. So they would actually pay the jurors, which we raised that as an issue because you don't want it to appear as though it's a case where he who pays, calls the tune. You don't want it to appear as though the jurors are going to find in a particular light because they are.
Or did we lose Miss Jess? And as you mentioned that, Miss Jess, by putting such a cost to it, it seems as only those with affordability could opt to elect having a trial by jury.
Absolutely.
And can you explain some everyday civil matters for the listeners? Because sometimes you hear the word civil and court, you think are rich people business them there.
Oh, it's very simple matters, like even defamation matters. Those are, the run-of-the-mill common ones. Somebody says, especially in social media age, somebody says something that causes you to lose your esteem in well-thinking, right-minded person's views, and you decide that you're going to sue because you want to protect your reputation. Those matters are matters that can potentially be tried by a jury. So civil matters are really just, in a nutshell, matters which are not of a criminal nature. So it really spans a wide breadth of various offenses.
Yes. Mr. Clark, last word to you, if Jade. I would love to hear Mr. Clark's view on that particular proposed amendment.
Yes.
Yes. What it is that I actually look forward to the Joint Select Committee meeting and determining this issue. So I know that the minister had withdrawn the bill, but I'm not quite sure, and this could help us with that, whether or not everything will be sent to the Joint Select Committee, or perhaps next week or another date, everything will be reintroduced without further debate for vote by the majority. So what one hopes nonetheless is that if the government intends to take fundamental changes that can somehow change the face of criminal justice administration, that those fundamental changes are done after it has consulted as wide as possible and have allowed persons who may be affected and different groups who may have input that could assist the drafting of proper legislation be permitted to make their submissions to Parliament before the final bill is sent to a vote and the majority rules.
Yes. All right.
Thank you.
Thank you both so much for just breaking down some of these critical provisions in a way that the public can appreciate, what is there. We really do appreciate your time taken from your busy schedule.
Thank you for having us.
Take care. That was Zulika Jess, attorney at law, opposition spokesperson on justice, and John Clark, attorney at law. Very important discussion, Jade and listeners.
Yes, I actually wanted to make a quick comment because I saw a comment in the chat here that says, it's funny, it's so funny, lawyers dismiss the ordinary man who is not schooled in the law when they comment on a case, yet the same lawyers are calling the ordinary man to be jurors. But you see, this is why I encourage us to serve for jury duty, because when you are a part of the jury, you are there to give your perspective as an ordinary man. You know, it is different when you're commenting on the conduct of a matter that has to do with, legislative provisions and so on. But when you're called as a juror, you are being called because of your expertise as an ordinary person, right?
And it's interesting, a lot of legislation, Jade, it has this terminology. What the reasonable...
Yes, reasonable man or an ordinary man.
And I'm like, who is the reasonable man? What does a reasonable man think? So, yes, the ordinary man, and we're using man in gender neutral terms at this moment, because the ordinary woman, I think I should be a part of the jury because that is what the law says. What does the reasonable person would have... this particular opinion on, and yes, it's so important, yeah,
because it's really about having a peer perspective. I think when we think about jurors, we kind of been thinking about them like they're secondary judges, but it's about having a peer perspective on this legal matter, right? And you have 7 to 12 of your peers looking at this and being instructed as to what the law says.
One of the YouTubers said, no, I'm an extraordinary man. Which is why we need extraordinary people.
Well, I find that we do have a quite extensive list of persons who cannot serve jury duty, so maybe you're one of the extraordinary people who cannot serve on the jury. But yes, the important perspective of a juror is to have a lay person's perspective. That is why it is so important.
Just to say, kudos to the ministry for tabling a bill, because we do need the ministers to be responsive to issues. And I think it's important that we start from that place of acknowledgement that the minister and his team saw it fit to make necessary proposals. The challenge I have, though, is what has been articulated by others, including Ms. Jess and Mr. Clark, that when you have a law that deals with fundamental changes with implications to our fundamental rights and freedoms, there needs to be robust discussion and a willingness to make necessary changes.
Yes.
So when you have a bill that proposes changes that talks about if I choose to elect a particular option to have my constitutional right realized, I must incur a cost.
Yes.
It's like when you're suing somebody, you know, and then when you lose the lawsuit, you say you have to pay a fee. You have to pay for legal cost.
Yes.
That cannot be what we're proposing. So I would love to hear the thought processes behind some of these things. And similarly, yes, one of the YouTubers said it beautifully, that before you empanel a jury, you must ensure that you're ready for trial. We agree. Mm-hmm. The question is there more? What is the thought process when you have procedural rules and the Criminal Justice Administration Act, for example, dealing with some of these things? So I just think it needs more and that robust discussion to be had. And dare I say, we've been down this road before.
Yes.
Remember, we passed, I think it was passed in the Senate, but I don't believe it has yet been gazetted. That's the proposals dealing with the mandatory minimum. Mm-hmm. For example, JFJ, in our recommendation to Parliament, said, listen, in our humble opinion, we understand the crime situation. We get it. The public is outraged. We need to start seeing people now not getting, in the public's opinion, lenient sentences. JFJ said, listen, we agree that there is need for review, but let us establish a comprehensive sentencing review commission to look wholesale on things. Yes. Let us look at things like the Plea Negotiations Act and so on, to ensure that when you pass a bill, it serves the intended purpose without having repercussions that we did not foresee. We saw it in the Firearm Act, yes, wherein, for example, people deciding that they're not going to plead because guess what? The mandatory minimum is such a big hurdle that if I am to be sentenced, found guilty and to be sentenced, I might as well tough you out and try
to win.
win and rely on the administrative gaps and hurdles, so witnesses no member no willing to come forward, and me just tough out and hope that 7 years pass and then by default I go about my business. Yeah. So these are the things that we're seeing, and we warned, defense attorneys warned JFJ, with you leading on it, Jade, we put these submissions. And then you hear the things that plea negotiation not being used. Then we hear the concern that backlog may happen, and therefore, so I just think we have to express a willingness. So when those who do the research, because I tell you, it's not little research we do to put forward these recommendations. And yes, Parliament may not listen, and we may not have the best ideas. We're humans, we're a small organization. But I think we have to do that comprehensive review, and I look forward to, for example, Jambar making their proposal known before, well, next week is tomorrow, no? Parliament meets tomorrow. Yes. But we hope that the robust discussion is had, because yes, some things are well intended and we should laud effort and the ministry is doing their work, but I think that engagement of the public is important.
Yes, absolutely.
Yeah. And to our listeners the same. Oh, someone is asking Jambar, Jamaica Bar Association. Yes. My apologies for just saying Jambar. But there's so much, because I wonder, Jade, would divorce, for example, no, that is already heard, Judge Only, the divorce.
Yes,
yeah.
Yes. It can be heard on paper as well. You know what, actually, I find that in the civil arena, we've made great strides in terms of speeding up how quickly you can get through a civil process. A lot of that can be done on paper. But when it comes to a criminal process where, you know, your accused has to be present in court, your witnesses have to be present and all of that, you tend to have a lot more gaps in terms of speediness of the procedure. I saw a question here asking, what's the Firearms Act about? The Firearms Act is the Firearms Act is the legislation that basically regulates how you can have weapons in Jamaica. So if you want to have a firearm legally, that is the legislation you would look at, and if you have a firearm illegally, that is the legislation you would be caught under.
And that needs some psychometric tests. You know, a different conversation, but I heard the head of FLA, which I agree. Man and woman, I get gun because brethren and sister have gun, and everybody want to have sitting pack up and listen, different conversation that I don't want to lose myself as JFJ head, but different conversation. You know, one of the challenges, Jade and listeners, that we have with sometimes not going before a joint select committee. Let me give you a real example. If you remember, women's organization, we have been calling for a comprehensive review of the Domestic Violence Act. Yes. I want us to use that as an example. A comprehensive review, because in the Domestic Violence Act, the term domestic violence itself is not even defined. Yeah?
Yeah.
You have a client who the partner abuses that client, physically assaults that client. And because if it's a physical assault, it becomes a criminal matter. So you go to court for that because you're the victim. Then there's some other components to it that may be heard in the parish level. Did you know that that victim has to go to two separate set of courts because we don't have what exists in other jurisdictions, which is called a unified court system, where a single judge will be hearing everything related to that matter. So JFJ, we made proposals. We did the research, late night, early morning, we did the research and we submitted that proposal to a joint select committee that was established. Now, while we welcome the 2 or 3 amendments that were made in late 2023, yes? Mm-hmm. A joint select committee was subsequently established. They met 2 or so times.
Twice, yes.
Mm-hmm. An election was held thereafter, and we don't hear peep about that joint select committee. So sometimes what you find is that the 1 or 2 amendments they are made, then another 1 or 2 other amendments made with real repercussions and consequences and implications for the entire justice system, for other pieces of legislation, but that comprehensive review eludes us.
Yes.
So it's just a food for thought, listeners, that, you know, as I said, we're not bashing because we support the effort. We laud the effort, but we have to look at the implications. Yeah,
I agree. A bit more fulsomely. Mm-hmm. Yes. I think it also saves time because, you know, when we do the reviews in this way, where we don't do our joint select and we push through provisions and gaps are flagged after the fact, we end up having to go back and then review these same provisions that we would have already spent time putting together to have them up to scratch. So I think it does save time and money, taxpayer money, when it is that we just do the review fulsomely from the beginning.
And Parliament, they really do need that Parliament building, by the way, because it helps with perhaps having multiple joint select committees.
Absolutely.
Yeah.
Because one of the challenges that we're seeing too is, you know, you have a meeting for Protected Disclosure Act, Joint Select Committee meeting for Protected Disclosure Act, and there's also a meeting to be scheduled for the Constitutional Republic Act, and we're fighting over who is going to get the chamber in order to do it, because of course there are other committees of Parliament that also need to meet, that are oversight committees that all meet in the chamber as well. So
and in addition to that, Jay, let me say this without apology. You have 63 members of Parliament and 21 senators. Yeah? We cannot have the same parliamentarians sitting on these committees like that, and kudos to those who are willing to serve. Don't misunderstand me.
Yeah.
However, we do need to ensure that the others play a more active role as lawmakers in the process. We have to take the break and then we just close out.
Yeah.
It's time for Hot Listings, Nationwide 90 FM's on-air classifieds, made for quick ads and fast results.
Hairdresser services available at Touched by Bella. Appointments from 8 a.m. Monday to Saturday at 26 Northside Plaza, shop number 5. Valentine's special, free shampoo and treatment with your service. For island twists, natural twists, knotless braids, locks, boho knotless, cornrows, ponytails, and more, call or WhatsApp 876-513-9082. That's 876-513-9082. Make your event come together with the right rentals. Popcorn machines, snow cone machines, elegant gold Chiavari chairs, 6-foot trestle tables, round tables that seat 8, bistro tables, and umbrellas for your round tables. Call or WhatsApp 876-304-0515. That's 876-304-0515. A supermarket in Kingston is seeking productive, mature, and responsible individuals. Positions include manager, supervisor, warehouse attendants, bulk room attendant, packers and baggers, cashiers, scullion, and servers. Send your resume to recruit.vasjamaica@gmail.com. That's recruit.vasjamaica@gmail.com.
That was Hot Listings on Nationwide 90 FM. Listings start as low as $1,500. Call 876-630-1210 to book yours today.
Welcome back to Let's Talk Justice. We have been discussing the matter of trial by jury, proposed amendments, but just generally looking at, how and when we review our legislation, the process in which we do that. And we're quite settled on the fact that comprehensive review is absolutely necessary. But I think that's the case for a lot of pieces of legislation that we.
By the way, one that we discussed last week in our launch. Thank you so much to Senator the Honorable Marlon Morgan, Parliamentary Secretary in the Ministry of Education, and Member of Parliament Nikisha Burchell, for speaking at the JFJ's launch of our Access to Information Act. Last review held, no actual amendments made. But the reason I mention it, because you popped up in my feed, Jade. Listener, she was on Smile Jamaica this morning. I haven't watched the interview. That's my news time, and I missed it. My apologies. But please take a listen and view Jay talking on the Access to Information Act. She presented the report on our behalf at the public forum that was held last week. And you heard some of the discussions on Nationwide with Ricardo Brooks and Sanjay Lewis last week. And another legislation that we're asking for a fulsome review of, plug. But if you were not able to take part in the public forum, we did record it, and there is the video of the proceedings and all of the presentations on our YouTube channel at Jamaicans for Justice, so you can go back and take a look at that. We did have a winner for our trivia question for today. Our trivia question was, which two lists do we take our jurors from? Which two lists of registered Jamaicans do we take our jurors from? The winner was News Commentator. And the two lists are our taxpayer registration list and our voters and
list.
I'm both, and nobody never called me yet. I pay my tax and my vote and all of these things. But anyway, nice News Commentator, second week in a row.
Yes, second week in a row indeed.
All right, that's where we have to leave it.
Indeed.
Thank you so much to our viewers and listeners. We appreciate your company, and see you next week. Hopefully it's going to still be a beautiful Monday morning, right? My name is Michael Jackson.
And I'm Jade Williams.
All right, enjoy your week.
Jamaicans, by justice, the people's champion. Justice for all, justice under the law, justice Jamaica demand, right to life, right to liberty. Out of many we are one in a Jamaica, make it a better place for the boys and girls, created equal by the creator, for equal rights and opportunities, no to unlawful detention and police brutalization. class, gender, race or religion. We not tolerate discrimination.
To join the fight against injustice, contact us at 755-4524 or JamaicансForJustice.org.
The people's champion.
It's Monday, get over your blues. Or Tuesday, Wednesday, Thursday, Friday. The E-Zone is here for you. With the Stinger Honeybee
and Karim Boyatings
from 3 to 5 p.m. on Nationwide 90 FM.
We've got your entertainment news.
Then we want to hear your views. Why you said?
Jump in the mix.
Or the